Hey legal studs! In this video, we're looking at the problems faced by individuals using the legal system. Past exams haven't generally asked questions directly on this topic, but they've asked questions on other topics that required students to have good background knowledge of problems faced by individuals using the legal system. Another thing to consider when you're studying this area is which elements of an effective legal system are hurt by these problems. There are three main problems that we discuss in the legal studies course. 1. Delays. 2. Costs. And 3. Social and cultural difference. First, there are delays, which impacts the principle of timely resolution of disputes and hinders a person's access to the legal system. Some delays are necessary in the legal system. Parties do need time to prepare their cases, after all. Yet many delays are unjustified and lead to unfairness in the legal system. For instance, in a personal injury civil claim, a plaintiff may experience hardship if he or she is forced to wait a long time to receive compensation. Witnesses may forget information if there is a long time before trial, and expert witnesses will charge more for their time if the trial itself is held up. In criminal cases, defendants may be held in remand and potentially have their liberty unfairly denied. With delays, legal costs also rise, which may cause financial hardship to the parties involved. Rising costs, as well as a lack of respect for the legal process, may deter parties from pursuing claims. Delays are caused for a lot of reasons. Courts often lack adequate funding and resources to efficiently carry out justice. However, parties may also deliberately delay proceedings. For example, lawyers may drag out pre-trial proceedings in a civil claim in order to put financial and mental strain on their opposition and force an out-of-court settlement. Second, we have costs, which also make the legal system inaccessible. Court costs are rising, while legal aid funding cannot meet demand. That means fewer people are eligible for funding. Increasingly, lower middle class and middle class people are ineligible for legal aid and are unable to pay for legal costs themselves. Parties don't just pay for court costs, but for solicitors and barristers, expert witnesses, and they will pay the opponent's costs if they lose a civil case. Costs will depend on the expertise of solicitors and barristers, complexity of the case, and length of proceedings. Finally, there's the issue of social and cultural differences. The Australian legal system is based on the British system, and therefore may neither be fair nor accessible to people who are unfamiliar with the system, or with its social and cultural context. Police powers and laws vary across different countries, and may create confusion for people who are accustomed to different cultures and legal systems. Features of the Victorian legal system, like bail, are not present in all legal systems, meaning the concept may be misunderstood. The adversary system of trial is not used in all countries, and as such, parties may not fully understand that they are responsible for preparing and presenting their own cases. There may be problems with oral evidence for non-English speakers, particularly if the evidence has no direct English translation. Judges and juries may also misunderstand a party's body language due to a lack of understanding of how a party's culture differs from their own. Cultural differences creating problems become especially apparent when you look at the participation of Aboriginal and Torres Strait Islander people in the legal system. Despite comprising only 3% of the Australian population, prisoners who identified as Aboriginal or Torres Strait Islander comprise 27% of Australia's total prisoner population. Aboriginal and Torres Strait Islander prisoners may be unable to secure a fair and unbiased hearing due to cultural differences and a lack of familiarity with the British-based legal system. In some Aboriginal cultures, direct questioning is seen as discourteous. This may lead police and the courts to view an accused with suspicion. Also, in some Aboriginal cultures, it is disrespectful to make direct eye contact, whereas in the Australian legal system, a lack of eye contact may be seen as a sign of guilt. Try and keep these problems in your mind when you're studying the course or doing practice exams. They can come up in lots of different areas. Thanks for watching and happy studying!
Click here to try and find the Engage Wiki, or click here now to see the next video. And now I need my broom.